There are various roles that need to be fulfilled in juvenile court, too. These different roles include the judge, the defense attorney, the prosecutor, as well as a probation officer or social workers that might provide evidence for the court, and also non-judicial support personnel. Each of these roles fulfills different functions for the court to be able to make a proper decision and to assure that the process is done properly. The judge is to assure that the legal issues are properly considered, but they are also there, to some extent, as a person that makes sure that the proper rules are followed. The judge interprets the law and should make determinations that are in compliance with the state's specific laws. The defense attorney takes on a variety of roles too, in that they are primarily an advocate for the child, but they can also stand in the role of the parent to some extent, and they may need to assist the court with assuring the services are found for the child. They also need to be a guardian of the child's rights in court. The prosecutor also has a primary role in the process of juvenile court in that they have multiple responsibilities. They have a duty to protect society, but they also need to help assure that the child's constitutional rights are given to them. The prosecutor is known as having a special duty in that they are to see that justice is done. This may also have a variety of meanings to different prosecutors. We talked previously about the youth being transferred from juvenile court to adult court. The next two slides helps you understand the differences and the similarities in various states regarding transfers of juveniles to adult court. These slides allow you to see the various characteristics of juvenile court, all of which are created by a specific statute or law for each state. Let's talk about some of these characteristics. The idea of the waiver being discretionary. This means that it's up to the discretion of the judge. Or the concept of the waiver being mandatory. This means that the statute determines who is waived to adult court, and that the court does not have discretion. So let's look at this idea of who gets to decide whether the child is waived up to adult court in Kentucky, about halfway down the page. If you look at the column for discretionary waiver, then look at the column for mandatory waiver, you see they both have boxes. And if you're tracking on the logic here, you might then think that this is contradictory. But we can make sense out of this apparent contradiction here because in most instances the determination to transfer is not discretionary, i.e. it's up to the judge in juvenile court. But in those cases where a firearm is used, the statute makes it mandatory that the youth is transferred to adult court. So it's both discretionary, as in most cases, but sometimes mandatory, as in firearm use cases. The column regarding reverse waiver, that is speaking to those states that require the more serious cases, meaning usually A and B felonies, to start out in adult court and then be transferred back to juvenile court if the child establishes that they should not be tried as an adult. And finally, I want to point out the last two columns, which refer to blended sentencing. This is an important aspect of the sentence. Blended sentencing allows for some of the sentence to be served in the juvenile justice system, i.e. until the youth reaches a certain age, such as 18 or 18 and a half years in Kentucky, and for some of the sentence to be served in adult corrections. So about blended sentencing. For example, in Kentucky, if a youth is tried as an adult and sentenced to a term of years for imprisonment, they would serve some of that term in a residential treatment center for youth. And then at age 18 or 18 and a half, they could be transferred to adult prison. This helps avoid the kinds of situations that we'll see later in the semester in the stick-up kid assignment. So, in Kentucky, a youth would be very unlikely to see this inside of an adult prison until they're 18 or 18 and a half years of age. And just for your information, in Kentucky, the youth are considered for probation at age 18 or 18 and a half. It's up to the judge to decide if they should have the opportunity for probation. That determination will depend on the seriousness of the crime, how a youth has done in treatment, as well as the recommendations of the prosecutor and the judge's individual views about crime, punishment, and rehabilitation. It's a highly discretionary decision by each judge. Speaking a little more about the actual waiver hearing, recall that it's sometimes called a waiver, a transfer, or even sometimes referred to as a fitness hearing. As we saw in the slides, specific criteria vary from state to state. The most common factors are the seriousness of the offense and the youth's amenability to treatment. Kentucky actually has an unusual statute, the only one of its kind in the nation. It actually looks at 8 different factors, and having any 2 of those 8 factors existing is enough reason to justify transfer.